chapter of Americans United for Separation of Church and State. I am going to say a few words first about Americans United, tell you a little bit about our chapter, and then I'm going to introduce our Vice President, Janice Rail, who will introduce our noted speaker for the evening. First, a few words about Americans United. Our organization is, the home office is in Washington, D.C. Nationally, we have over 100,000 members, and we are the only group out there today that argues for or supports church-state separation. So there are groups out there that work with us, but we're the only group that is 100% focused on church-state separation issues. Our message is pretty simple. All we ask is that government remains neutral with respect to religion. So we advocate that government neither favors religion nor is hostile to religion. We just ask that government remains neutral with respect to religion. Also, we are not anti-religious. Our members of our organization represent a broad cross-section of religious beliefs as well as non-believers. Our chapter, the Delaware Valley chapter, has a clergy advisory board made up of 5 local clergy members that advise us on religious issues. And Barry Lynn, our executive director, is an ordained United Church of Christ minister. So, no matter what you hear, we are not anti-religious. A few words about the Delaware Valley chapter. We have 2 mandates. We educate and we act as constitutional eyes and ears. Educationally, we hold events like this. We hold debates. We hold a symposia about once every 18 months. We hold conversations. We hold conversations between experts on church-state separation. So our goal is really to get the word out about church-state separation issues. Constitutionally, we are kept really busy. In New Jersey, we have Governor Christie, who just won't let up on his voucher program. He's reinitiated another push for vouchers in New Jersey. If you're not familiar with vouchers, they are basically a backdoor way of funneling taxpayer dollars to religious organizations. Also, another thing that we've been watching in New Jersey, in fact, we have one of our members is a plaintiff in this case. Americans United, along with another group, has sued the New Jersey administration, and it's over Governor Christie's earmarking $10.6 million to fund 2 New Jersey religious institutions. And I would say that if church-state separation means anything, it means that taxpayer dollars do not go to build religious buildings or to refurbish them. So we're watching those cases closely. In Pennsylvania, New Jersey looks like Berkeley, California, compared to what's going on in Pennsylvania. I'll give you a little history. Last year, there was a year of the Bible bill that passed unanimously. Long story about that, but it's pretty sad that a bill like that could pass unanimously. Actually, it snuck through because it was labeled as non-controversial. Last year was also the month of prayer bill. October 2012 was designated as the month of prayer. It passed. This year there have been a couple of nasty pieces of legislation, but the worst is the academic freedom bill. This passed just last month. It passed out of the Education Committee, and that is a flagrant attempt at sneaking creationism into our public schools. Initially, it was creationism. That got shot down in the courts, and then they tried intelligent design. That got shot down in the courts. And now they've come up with a new tact, and they call it the Academic Freedom Bill. And there's this, there have been academic freedom bills brought up in 15 other states. 2 states it's passed, 13 states it's been shot down. And again, it's just a sneaky way of getting creationism into our public schools by saying that we should be teaching the controversy and that evolution is a theory in crisis, you know, which is just baloney. It's really sad. So because of that, a group of us went to Harrisburg last month because we knew that this vote was coming up within the Education Committee, and I, along with Reverend Tom Beers, who is a member of our Clergy Advisory Board, had appointments to meet with a number of representatives on the Education Committee, hopefully to get to them and maybe talk some sense into them before this vote came up. And I just have to relay a little story here to give you a feeling for how bad it really is in Pennsylvania. And it's really only been this way in the last couple of years. We met with one member of the House of Representatives who sat on the Education Committee, and unfortunately, we wasted a little bit of time. We shouldn't have targeted the ultra-conservatives. However, we made a mistake. We're learning. This is a work in progress. Anyway, this particular representative, Reverend Tom Beers, and I went into her office. We sat down and we had a nice little pitch to give them. And I got about 5 minutes into the introduction, and she stopped me cold, and she said, you know, she said, the reason that I am pushing so hard to get creationism into our public schools is because I am being bold for Jesus. It gets worse. Before we left, she said that it's because of groups like Americans United that abortion is legal and women dress promiscuously. Cross my heart, he said that. So that's the kind of thinking we're up against in Pennsylvania. It's a tough crowd. So with that, I wanted to open up any questions or comments. Yeah.
What district is she from?
She's from out west.
Alabama,
Yeah, we're
Pennsylvania.
real close to the Alabama-Arkansas border. Yeah.
Are you doing anything about the In God We Trust bill?
Yeah, we did. Yeah, we mounted a strong letter writing campaign. In fact, I was interviewed on 2 radio stations just about that bill, and we had 1 or 2 op-eds published in papers. Yes, we are very sensitive and aware of it. Any other questions? If you like what we do, if you support what we do, I strongly urge you to become members if you're not already members. If you are a member, don't forget to renew. If you're not a member, I strongly urge you to sign up and join for a measly $35 a year. You get Church State Separation Magazine, which is an excellent little publication. It comes monthly. But most importantly, you get bragging rights to claim membership in such an auspicious organization as Americans United. So with that, if there's no more questions, comments, I will introduce Janice Rail, our Vice President, who will introduce Rick.
Hi everybody, I'm Janice Rail. I am the founder of the DVAU chapter and Vice President. If you interact with us online at all, you're interacting with me. Pretty much I do the Facebook, the Twitter, the Meetup, the website, and all the other fun internet stuff that we get to do for the chapter. So tonight I'm very excited that we have from Washington, D.C., we have Americans United's lawyer, Greg Lippert. Greg Lippert is from the legal department at Americans United for Separation of Church and State. Tonight he's here to talk about government, God, and the town of Greece. The Supreme Court revisits legislative prayer. AU's legal team represents the 2 women who launched Town of Greece versus Galloway, the first Supreme Court case in over a decade to consider the limits of government-sponsored prayer. Greg will provide insight into the case and what to expect next. Greg Lipper currently represents the respondents in Town of Greece versus Galloway, the first Supreme Court case in over a decade to consider the limits on government-sponsored prayer. Greg joins Americans United in January 2011, was named a 2013 Rising Star by Super Lawyers. He has authored over a dozen amicus briefs and in federal appellate courts defending employees' access to contraception against religious exercise challenges. Before joining Americans United, Greg spent 6 years at Covington & Burling LLP, where his practice included trial and appellate litigation, white-collar criminal defense, and First Amendment advice. Greg also represented parties or amici in nearly 20 cases before the U.S. Supreme Court. Greg is a barrister in the Edward Koch Appellate Inn of Court and sits on the board of directors of Washington Council of Lawyers. He speaks regularly across the country on a broad range of First Amendment issues. Greg received his J.D. magna cum laude in 2003 from Harvard Law School. He received his B.A. with honors from Northwestern University in 2000 and was a national intercollegiate champion in extemporaneous speaking. And now may I introduce Mr. Greg Lipper.
Thank you, and thank you for coming. So, as you may have seen sort of news coverage about this case, and you probably saw all of the newspapers that had puns on the name of Greece. So you had, Supreme Court visits Greece and similar things. This Greece is not in Eastern Europe, but is instead in upstate New York, in a suburb of Rochester. And every month, like most local communities, its board, which operates as its town council, holds meetings for the public. And until 1999, the Greece Town Board opened its meeting with a moment of silence. It was nice, it was inclusive, didn't cause any problems. And then in 1999, a gentleman named John Auberger was elected town supervisor, the equivalent of the mayor position. And he decided to institute a prayer. And at first, Supervisor Auberger would deliver the prayers himself, and then soon he and the board started inviting a rotating cast of what they called guest chaplains to deliver the prayers. From 1999 to 2007, every single one of the guest chaplains, or what the town calls the chaplain of the month, was Christian. And during that time period, in which 100% of the guest chaplains were Christian, over 2/3 of the prayers themselves were explicitly Christian. And no other religion was referenced in any of the prayers. And to be clear, when I say that 2/3 of these prayers were explicitly Christian, we're not talking about little subtle references at the end that you have to be paying really close attention to here. They included prayers like the following one, and I quote, "We look with anticipation to the celebration of Holy Week and Easter. It is in the solemn events of next week that we find the very heart and center of our Christian faith. We acknowledge the saving sacrifice of Jesus Christ on the cross. We draw strength, vitality, and confidence from his resurrection at Easter. Jesus Christ, who took away the sins of the world, destroyed our death through his dying and in his rising. He has restored our life. Blessed are you, who has raised up the Lord Jesus. You will raise us in our turn and put us by his side." So as you see, this goes well beyond the, pray that our leaders make wise decisions for our citizens, and really starts to sound far more like a church service or a sermon than something you would think at your local grassroots democratic meeting. Now, let me stop for a moment, because you may be thinking to yourselves, I've read the Constitution. I don't understand, how is it the government is sponsoring prayers at all, let alone prayers like this? And it's a good question, because it does seem anomalous that the government would be in this business at all, of sponsoring prayers at official government meetings. There is a 1983 decision of the United States Supreme Court called Marsh versus Chambers, and it created basically an exception to the normal rules providing for the separation of church and state. So this decision involved the Nebraska State Legislature, and actually was a challenge brought by a member of the Nebraska State Legislature challenging that legislature's practice of employing a chaplain who would open the legislature's sessions with prayers. And so Chambers went up to the Supreme Court and he said, look, this is government-sponsored prayer. This is very clearly the government furthering religion, advancing religion, endorsing religion. This is unconstitutional. And the Supreme Court, however, created an exception, declined to apply the normal Establishment Clause rules, and instead what the Supreme Court said was, our first Congress, back in 1789, 1790, opened their sessions with prayers. These were the same people that wrote the First Amendment. Therefore, if the first Congress was doing it, it couldn't possibly have violated the First Amendment, and so we're going to uphold this practice. Now, there are a number of concerns with that logic. As Justice Brennan pointed out in his dissent, the same Congress in the 19th century that proposed the 14th Amendment then turned around a week later and voted to continue the racial segregation of the DC public schools. And so obviously, the fact that an amendment's authors did something doesn't mean it necessarily complies with the amendment. But in any event, that was the Supreme Court's decision 30 years ago, and it remains the law of the land. Now that said, there are a couple of important aspects of that decision, which means that even if you accept that this decision is the law of the land, whether or not you agree with it, it does not mean that the floodgates should be open to any and all types of prayer at any level of government, no matter how much it affiliates the government with a single religion. And I think there's really two important aspects about the practices in Nebraska that were upheld. The first is that in the state legislatures and in Congress, the members of Congress are really ministering to themselves, because you don't have the sort of public hearings that characterize local government. To the extent the public is attending these sessions, it's as tourists or as visitors. You're not going up and asking your senator to rezone your backyard to allow you to open up a shed or something like that. So it really is a much more internal process. And while there certainly is pressure created, it's at least pressure amongst colleagues, amongst fellow legislatures, not the government imposing prayer pressure on the citizens. So I think that's the first important point to remember about Nebraska, the state legislatures, and Congress more broadly. The second important thing is the content of those prayers, because there was actually a lot of discussion of this in the Supreme Court's decision. By the time the case came to the Supreme Court, the prayers, the explicitly Christian references had been removed by the chaplain. In fact, in response to complaints from a Jewish legislature. And so by the time the prayers were up in front of the Supreme Court, they were non-denominational. And what the Supreme Court said was, quote, "The content of prayer is not of concern to judges, whereas here there is no indication that the prayer opportunity has been exploited to proselytize or advance any one or disparage any other faith or belief." And the Supreme Court in future cases has reiterated that not even the unique history of legislative prayer can justify contemporary legislative prayers that have the effect of affiliating the government with any one specific faith or belief. And so even in this unique context, this exception governing legislative prayer, the Supreme Court has made very clear that the government may not use those prayers to affiliate itself with a single religion. The government cannot use its legislative prayers to advance Christianity, for instance. So that's the law of the land. Since that decision, we've seen the shift from state legislatures to local governments, and we've seen situations like in the town of Greece, where you do have local governments affiliating themselves with a single religion. And so if you remember, as I told you at the beginning of the speech, in the town of Greece from 1999 to 2007, 100% of the prayer givers were Christian, and 2/3 of the prayers themselves were explicitly Christian. No other religion was represented. There were other things that the town did to affiliate itself with the prayer givers and thus the prayers. The town supervisor would actually announce the prayer giver's religious affiliation and the name of his or her house of worship. And those religious affiliations were noted in the official town minutes. When the supervisor would have a special relationship with one of the pastors, he would point that out. For instance, he pointed out that today my pastor is coming up and serving as our guest chaplain. Another important thing is that for most of the meeting, when you're speaking at one of these meetings, the podium is facing the board. So if you're the board and I'm a citizen, I would face you. But when it came to the guest chaplain delivering the prayer, the podium was turned around. So the chaplain is up here, the board is behind, and the audience is out here. So another step to really affiliate the speaker with the government. Oftentimes, the guest chaplains ask the audience to join in the prayer, sometimes to bow their heads or to stand. And members of the board will often participate by bowing their heads or standing or making the sign of the cross. And on one occasion, the audience was asked to stand for the prayer, and the board all stood. And so in that situation, if you're deciding to stay in your seat, you're going to look pretty conspicuous. So this went on for 8 years. And in the summer and fall of 2007, Susan Galloway and Linda Stevens started expressing concerns. Ms. Galloway is Jewish, Ms. Stevens is an atheist. Both of them are longtime residents of Greece. Both have attended Greece board meetings for years. And like many citizens, they came because they were interested in particular local issues. Things like who was getting the contracts for local cable television. What were the plans for land development? Very core governance issues that are decided at these meetings and at these meetings alone. And both of them felt pressured to join in these consistently Christian prayers, and then felt like second-class citizens when they declined to join them. So they raised their concerns with the town supervisor. That did not get them anywhere, and in fact, at the very next meeting, the chaplain of the month stood up and said that those who opposed the town's practices were in the minority and were ignorant of the history of the country. And then, of course, he delivered his prayer, and the town supervisor thanked him and gave him a plaque, commemorating his serving as the chaplain of the month. And so it was very clear, as sometimes happens in our cases, that the only way that we were going to do something about this was to file a lawsuit. And so we did. So in February 2008, we filed a lawsuit in federal district court in Rochester. And the town, in turn, was represented by a group called Alliance Defending Freedom, which is a religious right organization which itself describes itself as a Christ-centered legal advocacy organization. And, these guys are not especially subtle, but they're also not stupid. And in response to our lawsuit, for the first time, the town tried to create the appearance of a much more diverse and inclusive prayer practice. So for the first time in its history, in 2008, there were actually non-Christian prayer givers at 4 of the meetings. A Jewish individual delivered a prayer on 2 occasions, a Baha'i individual delivered a prayer on 1 occasion, and a Wiccan priestess delivered prayer on another occasion. So you had 4 non-Christian prayers in 2008. The rest of 2008 was Christian prayer givers delivering Christian prayers. And in 2009 and 2010, as the lawsuit was continuing, it was again entirely Christian prayer givers. And in fact, whereas before we filed the lawsuit, 2/3 of the prayers were explicitly Christian, in the time period while the lawsuit was pending, that figure actually went up to 80%. And so you had the briefest of flirtations with religious pluralism as a litigation strategy, and even that they couldn't keep up. So we went through discovery, we took depositions, exchanged documents, etc., etc. And then in 2010, the federal trial judge in Rochester ruled for the town. And he said that there was no evidence of specific discrimination against Christian prayer givers. In other words, he said there's no evidence that the town is intentionally excluding non-Christian prayer givers. It just so happens, given the town's demographics, that that's who you're getting. And he said that as long as those prayer givers are not specifically attempting to convert anyone to Christianity or specifically insulting anyone else's religion, it was not for the courts to look at the content of what they were saying. We appealed to the U.S. Court of Appeals in New York, and that court reversed, ruled in our favor in a unanimous decision that was joined by both Democratic and Republican appointed judges. And what the town did was looked at the totality of the circumstances. They pointed to a number of the things I mentioned earlier, that the prayer givers were almost always Christian, that the prayers almost always had explicitly Christian references, and all of the conduct by the board members suggesting that they were, affiliating themselves and going along with the prayers. And what the court said was, where the overwhelming predominance of prayers offered are associated, often in an explicitly sectarian way, with a particular creed, and where the town conveys the impression that town officials themselves identify with the sectarian prayers, and that residents and attendants are expected to participate in them, the Constitution has been violated. Now, the town turned around and sought review to the Supreme Court. And this has been an issue that has been coming up in a number of cases across the country, both cases we've brought and cases other organizations have brought. There have been cases in North Carolina, a number of cases in North Carolina, cases in Florida, cases in California, cases in Delaware, and on and on and on. So there have been a number of cases, and so it was in some sense a matter of time before the Supreme Court was going to decide to hear one, and they chose ours to hear. So in May, the Supreme Court announced that they're accepting review, and briefing started over the summer. The town filed its brief in July, and then we filed our brief in September. The town filed its reply brief in October, and then the case was argued last month. So let me walk you through the main arguments we're making, and also give you a sense of the types of questions the justices were asking at the oral argument. So there are two basic points we're making here, and I think if you've been listening to what I've been saying so far, they're not going to be huge surprises. The first centers around the notion of coercion. It's among the most basic of principles that the government may not coerce citizens to engage in religious exercise. And the setting of the prayers in these town board meetings, including in Greece, create an enormous amount of pressure on citizens to do just that. As I mentioned, you are going to these meetings not just as a spectator, but as participant and often as a petitioner. Town employees are getting sworn into their offices in front of their supervisors. There's a public comment period where citizens go to complain about crime or noisy neighbors or a lack of parking for people with disabilities or a number of other issues. And oftentimes members of the town board will actually take action right then and there. And remember, we're dealing with a very small crowd and highly discretionary decisions. And so, staying in the favor of the town board is very important. The other thing is that they're actually official public hearings. So if you want to open a business or get a zoning variance or do any number of things that requires actual formal approval, those take place at these meetings. You present your case, members of the public can comment, and again, the town board votes, and again, making very discretionary decisions that are very hard to get reviewed after the fact. And so, in light of that, in light of the fact that you have a very small crowd, smaller than this crowd here today, you have people up in front of you introducing their guest chaplains, watching very closely, who can see very clearly who is participating and who is not, and then who are going to be acting and ruling on your very discretionary requests. You can see how there's going to be quite a bit of pressure to go along. Now, some say, well, just leave for the prayer and then come back, but there are a couple of problems with that. First of all, everything moves very quickly. You have the Pledge of Allegiance, and then the prayer, and then people get sworn in, and then there's a public comment period, and it all moves in rapid succession. So even if you wanted to do that, you would really have to be like standing outside the door with your ear, and then like dashing in when you wanted to come back. Even if you were willing to do that and able to do that, everyone would notice, and if you came to multiple meetings, everyone, oh, that's that person that always leaves for the prayer and citizen to play musical chairs at their town board meeting, it's simply not feasible, and even if it were feasible, it's having a very effective outing yourself as a religious dissenter. Now, one thing that the town argued was that, well, these public hearings are separate from the town meeting itself because their scheduled town meeting starts at 7, these public hearings start at 7:30, and so all you have to do is show up for the public hearing and don't worry about the stuff that comes before it. You know, a couple of things about that. First of all, I think they're dramatically overstating the separation. Like, it's not like the first stuff happens and then everyone gets up and goes to the back and drinks coffee and, you know, eats muffins and then comes back to their seats and it's like a whole new meeting. It's basically the meeting's going along, and at 7:30 they just start the public hearing. But it's not a separate thing in time. Most people would see this as one meeting. And if you were advising a client who is going to be up there at the public hearing at 7:30 to press their case, you would probably tell them, yeah, be polite, show up at 7, sit there, see what the town board is doing. In the same way, when I'm arguing a case before a court at 9:45, I show up at 9 and watch the arguments before me so I can see what's going on. You know, and this came up, so the Justice Department of the federal government actually filed a brief on the town's behalf. And they did that in part because Congress has its own legislative prayer practice, and I think the government is worried about getting sued over those practices. But the government, in its oral argument, pointed to the fact that these public hearings are at 7:30, and so they're different and separate, and so that is enough to eliminate any coercion. And Justice Kagan asked the DOJ lawyer point blank, so are you saying that if these hearings weren't at a fixed time, you would be in on the other side? You'd be supporting our side? And he said, well, no, I can't say that. And so it really, you know, it's really very much a red herring. The town is making a broader argument. They are saying that when it comes to adults, there is no such thing as coercion by pressure. There's either a formal legal obligation to join in other words, like, if you don't join this prayer, you're going to go to jail or pay a fine. And if there isn't that, they say there's simply no pressure when it comes to adults. Now, the Supreme Court has held in the context of students in high school graduations, football games, that students are certainly capable of being coerced even without a formal legal penalty due to peer pressure, pressure from their teachers and the like. And so the only question is, are adults categorically different? Is there something in adults' brains that makes them categorically immune from pressure in a way that students aren't? And the answer to that is no, and we point out a number of studies in our brief. You know, there's studies going back decades showing that adults themselves are very susceptible to pressure, you know, from their peers, from authority figures, and especially when those authority figures are in the same room with them. And that's exactly what's going on here. They have their peers, they have authority figures, and those authority figures are in the same room with them. So, I mean, you could pretend, I suppose, as the town has asked the court to do, that adults are categorically immune from pressure. But if you think that the Constitution protects freedom of conscience in a real sense and not just in a formal sense, then you really have to grapple with that. And you really have to see that, you know, the people in this town are going to feel pressure in this very small, intimate environment. Yes?
Also, children are often allowed into city council meetings.
That's right. In fact, so they're right.
Sometimes they have field trips.
Exactly. And in the town of Greece, there are oftentimes children there. There's athletic teams that are getting honored if they, you know, win the state tournament. There are local youth organizations that are getting honored or that are participating. There's examples in the record of a local youth group that was invited to deliver the Pledge of Allegiance. They went up, delivered the pledge, sat down in the front row, everyone watching them. Then the guest chaplain stood up, delivered the prayer. Guest chaplain sat down, and then those kids were called back up again to get recognized. And so you have kids in a very captive audience in the front row, everyone watching them, with literally about 45 seconds between their first participation in the meeting and their second participation in the meeting. And that is, you know, far greater pressure than, for instance, kids at a football game or kids at a graduation, in which the Supreme Court has said, you know, they need to be protected from that sort of coercion. And in fact, at the argument itself, Justice Sotomayor, for instance, asked the government lawyer, if you're at one of these meetings and the guest chaplain asks everyone to stand, how many people do you think are going to stay seated? And the government lawyer was quite candid, not very many. If you think, or if you adopt a rule that adults simply cannot be coerced unless there's a formal penalty in place, you will get situations like you had recently at a utility rate hearing in Alabama, where the rate commissioner, before the rate-making hearing began, introduced her friend, a clergy, talked about how good his morals and his religious values were, asked everyone to stand, turned the floor over to this guest clergyman, who invited the prayer givers to raise their hands if they believe in prayer. And then while everyone was standing, he led a nearly 4-minute prayer, and he proclaimed at the end, God, we've taken you out of our schools, we've taken you out of our prayers, we've murdered your children, we've said it's okay to have same-sex marriage. God, we have sinned, and we ask once again that you'll forgive us for our sins. I ask in the powerful, the most mighty name, the name that's above all names, and that's Jesus. Everybody say, amen. And right after that, everyone sits down, and then you go up and plead your case for the setting of the rates. That is about as coercive as you can get, and under the town's theory, the Establishment Clause has nothing to say about it. And there are a number of actually simple steps that can be taken to significantly reduce the coercive pressure. For instance, instructing guest chaplains not to invite the audience to join or participate or manifest physical assent, or turn the podium around so that the guest chaplains are in the same position as any other speaker at the meeting, which is facing the board who they're intended to be ministering to. But some remedy we believe is necessary to alleviate the significant intrusion in conscience that comes when you are under overwhelming pressure to join in a religious exercise you may not want to join in as a price of participating as a citizen. So that's the first major argument we have made, the coercion inherent in these meetings and in the way these prayers are delivered. The second major argument we made has to do with the content of these prayers, because these prayers are not only prayers, as were admittedly upheld in the Nebraska case, but prayers of a specific faith, and in fact almost always to a single faith. And like the prayer I read to you at the beginning, these are explicitly and often elaborately Christian. There have been references to the saving sacrifice of Jesus Christ on the cross, to the plan of redemption that is fulfilled in Jesus Christ, the life and death, resurrection and ascension of the Savior Jesus Christ, the new life of the risen Christ, the workings of the Holy Spirit, the belief that God has raised up the Lord Jesus and will raise us in our turn and put us by his side. The town has somewhat half-heartedly tried to argue that requiring that the prayers be non-sectarian would put courts in an impossible position because in many instances you can't tell the difference between a non-sectarian prayer and a sectarian prayer. That may be true on the margins, but the prayers that I've just read to you, does not require the Pope or the Ayatollah to tell you that these are affiliated with a particular faith. And, Justice Sotomayor at the oral argument at one point said to one of the lawyers, it's like, come on, these are obviously Christian prayers, right? And they said, yes, they are. Another argument that the town made was that if the government is instructing the guest chaplains to deliver more inclusive prayers, then that amounts to government censorship, or amounts to government composition of prayers. And that is something that the Constitution does not allow. Now, on one level, yes, that's right, but we're here because 30 years ago the Supreme Court said the government can be involved in having its own prayers. And so you're already in a situation where this is the government's message, it's the government's prayers. So At that point, to say, well, the government can have these prayers and can deliver these prayers, but we don't want the government in the business of deciding what kind of prayers are delivered is, it's equivalent to asking the government to be half pregnant. More generally, there are all sorts of instances in which when the government is the messenger, the government gets to control its message. So, for instance, when the government hires a IT contractor to build a website, let's say, for a new healthcare program, no one would suggest that it would be censorship if the government told the contractor, when you build the website, make sure you encourage people to sign up. That the contractor wouldn't have the right to say on this website, healthcare, don't worry about it, this is all a scam, go with that, take your chances, you'll get treated in the ER. Obviously, if someone was building the government's website and said that, the government would, of course, be able to say, no, that's not the message we want on this website that you're building for us. And it's really no different when the government is the one who's delivering the prayers. The fact that it is delegating its responsibility to an invited guest chaplain, rather than having a chaplain on its payroll, doesn't change the ultimate fact that this is the government's message. This isn't a private message. There is a public forum in the Greece Town meetings. It happens later on. Everyone gets 3 minutes. You're facing the board, not the audience. And when I stand up and say something, the next person can stand up and say that I'm an idiot. That's not what's going on with the prayer when it's a guest chaplain given a special place on the program, facing the audience in front of everybody. Now, I will say there was some concern from justices at the Supreme Court argument, especially Justice Kennedy, about the idea of censorship. We don't think there's anything to that argument, but it was something that Justice Kennedy in particular did seem concerned about. He seemed very uncomfortable with government controlling the content of prayers, even though this was the government's own prayer practice. Even though it's the government's own prayer practice, and even though the notion of guidelines to guest clergy to be inclusive is actually quite common. The National Conference of State Legislatures, for example, has endorsed guidelines that tell their guest chaplains to use common language and shared symbols that would be acceptable to a broad group of people. Local governments in the National League of Cities have similar guidelines instructing guest chaplains to be inclusive, recognizing the fact that there are people in the audience coming from a variety of faith traditions. The flip side, too, is that if any instructions to clergy to make prayers inclusive amounts to intolerable censorship, then absolutely anything goes. And during this case, when we were taking depositions, we asked the town supervisor, would the town permit a prayer giver, a guest chaplain, to lament the evils of homosexuality? And he said, we do not control the content of prayers. And then we said, what about a prayer to, quote, our white Lord Jesus, to grant peace to the white residents of Greece, but not the blacks or Jews or homosexuals or other perverts. We do not control the content of prayers. And so, if any guidelines, if any instructions, if any efforts to make these prayers inclusive is impermissible censorship, then all bets are off, and anything goes, and prayers, disparaging prayers, proselytizing, the most divisive, incendiary prayers, Fred Phelps from the Westboro Baptist Church, is fully allowed at government meetings before a captive audience of citizens who are about to plead their case. The other series of questions we got about this argument we were making came from, in particular, Justice Alito, Justice Scalia, and Chief Justice Roberts. And it was along the lines of, identify for me a single prayer that would be acceptable to Christians, Jews, Hindus, Buddhists, atheists, and everyone else. In other words, you say you want the prayer to be inclusive, but no prayer can be fully inclusive of everyone. Now, at some level, that's true, but it's a very odd circumstance in which the increasing religious diversity of our nation is being used as a justification to do nothing about the fact that most of the prayers at the town's board are affiliating themselves with a single religion. Because I think that's an important point to remember, that these questions were not saying, hey, we really need to do more to protect atheists, Hindus, Buddhists. This was, because there are all these groups and because you can't satisfy anyone, it's totally okay if all of the prayers are Christian. Now you may have seen in the news coverage there was an exchange in which Justice Scalia asked the lawyer arguing for our side, well, what about the atheists? You know, you've sold out the atheists if what you're saying is the prayers have to be non-denominational. And again, I think that is a function not really of our argument, but a function of the fact that 30 years ago the Supreme Court said government can open its legislative meeting to prayers. We were before the court acknowledging that this decision from 30 years ago was the law and was unlikely to be overruled. But there still, in our view, is a significant difference between a prayer to God and a prayer to Jesus Christ. Or between saying, God save this honorable court, as the Supreme Court does, and Christ save this honorable court. Or between having, in our Pledge of Allegiance, one nation under God, or one nation under Christ. Or having on the money, in God we trust, as opposed to in Christ we trust. The references to God by the government certainly are not fully inclusive. There are certainly very valid objections to them. But the fact that those are allowed does not mean that the government should be able to go a step further and actively affiliate itself with specific religions. Then there's this question about what the town is arguing is, look, we have an open selection process. Anyone who wants to come and pray can pray. It's a heavily Christian community. It's not our fault that most of the prayer givers are Christian. You know, what do you want from us, essentially? And I think there are two important responses to that. The first is that that's actually not what's really going on. At first, the instructions to the town clerk were to, quote, call a pastor. Over time, the town adjusted its lists and made them slightly more inclusive, but always in a haphazard fashion. At the end of the discovery period in the case, they submitted their new and improved list that supposedly had hundreds of different names of different religious organizations from all of these different faiths, but a lot of them were very questionable. Many of them were cemeteries. Many of them didn't have phone numbers. Even then, they didn't seem to be calling it in order. So right off the bat, there's very much a factual question about how much of an effort the town made to be inclusive. Even if they had been genuinely inclusive, even if they really had absolutely opened it up, you're still basically saying if a majority of the townspeople are Christian, then it's okay to impose Christian prayers on everyone in the town, whether or not they're Christian. And the very basic premise of the Establishment Clause, of the separation of church and state, is that the majority does not get to impose the religion on the minority. There's even more specific problems, which is that, you know, Greece is a town of 100,000 people. Let's say, there aren't statistics on this, but let's say it's 90, 95% Christian. That's still 5,000 or 10,000 people who do not practice Christianity in that town. There may not be very many non-Christian houses of worship because many of those people will go to Rochester or some other place, you know, to worship. But when you limit your selection process to clergy within your town's borders, you're going to get a situation where almost all of your guest chaplains are Christian, and the people who aren't Christian are not going to be protected. And at oral argument, Justice Breyer was very much trying to get the town to commit to a more affirmatively inclusive practice. He said, you know, would you look out to other towns? Would you invite non-clergy? And the town's lawyer first said, well, I'd have to consult with my client, but second, we think it's appropriate for us to be inviting clergy within our town's borders. And if you do that, you're going to get a situation where 98, 99, 100% of the prayer givers are Christian, in which you are reducing the Constitution and freedom of conscience to a head-counting exercise. The final point that both the town has been making and that many of their religious right allies have been making is that this isn't really a big deal. It's just all you have to do is sit there and listen to something you may not agree with. That's part of being a citizen. I want to read you a couple of quotes and a couple of statements that have been made both by our opposing counsel and their allies, because I really think it it nicely captures their attempt to really belittle the serious concerns about freedom of conscience that we think are at issue here. One lawyer from our opposing counsel says, Americans shouldn't be forced to forfeit this freedom just to appease someone who claims to be offended by hearing a prayer. Another lawyer from our opposing counsel says the, quote, the eggshell-thin sensitivities of the most easily offended prevail, and that these are paltry personal complaints like offense. A lawyer from one of their allies refers to our clients as, quote, the professionally offended. But, you know, this is not a matter of being offended. This isn't me hearing someone on the radio who I think is an idiot and wanting to change the channel. This is a captive audience who are facing significant intrusions on their conscience. And you know, to say that is not to belittle religion, but it's actually to take it seriously. If you are forced or pressured to join in a religious exercise that is at odds with your conscience, that's not just being offended. That doesn't reflect an eggshell skull. That reflects, you know, a serious belief in your conscience that is being intruded upon here. And so to say it's offensive, it's, you know, eggshell skulls people is really to belittle the serious claims that are going on here. And we are now, as a country, you know, there are now 70, 75, 80 million Americans who are not Christians. So this isn't just like, you know, two gadflies interfering with this otherwise like national harmony. This is a significant number of Americans who does not worship in the way that the majority worships. If you could imagine the shoe being on the other foot, I should add, I think you would be getting a very different reaction from our opponents on the other side. If, for instance, we were, say, in Dearborn, Michigan, and the city council was majority Muslim, and the imam of the month stood up and opened the meeting asking the audience to stand and face Mecca, and gave a prayer proclaiming that Allah is the greatest, and there is no deity but Allah, and Allah is the one, and glory be to Allah, the Almighty, as everyone bows. You would be getting a very different reaction from the same people that right now saying that non-Christians should just stop being offended. To give you an anecdote, one of the affiliated attorneys, affiliated with our opposing counsel in California, recently brought a lawsuit against a school in California arguing that their teaching yoga in gym class was imposing Hinduism on his clients. Now, the court looked at the program and found that it wasn't actually religious, that anything possibly religious had been removed, and it was essentially just exercise. But if the town was actually trying to impose Hinduism on students, he would have a case. But he said when he felt that Christian students were having a different religion imposed on them, he described it as the clearest case of the state trampling on the religious freedom rights of citizens that I have personally witnessed in my 18 years of practice as a constitutional attorney. Suddenly we weren't talking about professionally offended. Suddenly we weren't talking about eggshell-thin sensitivities. Suddenly we weren't talking about, paltry claims of offense. And I think that is ultimately an important point, and it was one made by one of the briefs filed on our behalf by a group of religious minorities, that this case is, on the one hand, very much about protecting religious minorities, but it's also important to remember that today's minorities may be tomorrow's majority, and vice versa. And as this country gets more religiously diverse, as we have a greater number of people of a wide array of faiths, and as we start to see, even in some towns, majorities of faiths other than Christianity, it is increasingly important that at these town meetings, at these core civic engagements in which citizens and the government are at their most, are at their closest and are communicating most directly, it is especially important to protect the freedom of conscience of citizens, and it is especially important that the government avoid affiliating itself with a single religion. Thank you for coming. I'm happy to take questions.
Yes. Did you get any sense from the questioning at the court that the sound board has gained any traction with the justices?
So let me give you my standard disclaimer, which is that it's very difficult to get the sense of the justices from their questions, and even if you have it, it's sort of bad luck to predict it. You had certain justices did pick up on it. Justice Kagan, the long Kristen prayer I read to you at the beginning, she actually about 30 seconds into the argument read that prayer and then was talking about, we're really at the local level at sort of the core citizenship, exercise of citizenship, and it's especially important to hear that citizens not be forced to identify themselves with a particular religion. Likewise, Justice Ginsburg pointed out that not just that we're at the local level, but these are somewhat legislative, but there's also they're administrative, they're adjudicative. These aren't entirely legislative settings in the way that the state legislature and Congress are, precisely because you have zoning decisions, licensing decisions, more along the lines of what an agency or a court would do. So there certainly were, I think, certain justices pointing that out. I mean, I will say, when that discussion was going on, Justice Kennedy asked a question suggesting that he did not like the idea of courts looking at the particular legislative body and deciding, like, is it more like the state legislature, or is it more like a rate-making board? So I think there were definitely, and Justice Sotomayor, in asking her questions, again, seemed to be very worried about the pressure being faced by people who were about to present petitions. So I think some of the justices were concerned. Justice Kennedy seemed to not want to go there, and then the rest of the justices didn't really ask questions that would suggest one way or another that they thought it should be treated differently. I mean, I will say Justice Kennedy, going a little further, there was one point in which he said, isn't it elitist to be saying that, the folks in Sacramento and Austin can do whatever they want, but, at the local level up in Greece, they have greater restrictions. So, I think it's fair to say Justice Kennedy, at least based on his questioning, did not seem persuaded by the distinction. Justice Ginsburg, Sotomayor, and Kagan, I think, did, and I think the rest of them didn't really speak to that issue. So, yes.
Greg, is AU arguing that the prayers that prayers are okay, but they should just be more inclusive?
We are arguing two things. The first is that the prayers need to be, if they're going to be delivered, need to be non-denominational or non-sectarian. And that, to be clear, and we've been engaged in a dialogue with certain other allies of ours about this, I think we're not, we did not go up there saying, all right, let's, sell out the atheists. We have an atheist client ourselves, but it's really more recognition that the Supreme Court, in this case 30 years ago, said that legislative bodies could begin their sessions with prayer. And so taking that as a given, we do think both, given the language of that decision and the need to accommodate growing diversity, that those prayers do need to be non-sectarian. But there's a second part of what we asked for, which we think is important regardless of how inclusive the prayers are, which is the protections against, for instance, being asked to join, being asked to physically participate. Those sorts of things we think are equally important, because even if the prayer is non-sectarian, even if the prayer is non-denominational, nobody should be forced or pressured to join in it. And so what we're really saying is two things. The prayers do need to be non-denominational, but if you're having any prayer whatsoever, there need to be protections so that nobody is forced or pressured or otherwise feels compelled to participate in the prayer that they don't want to.
Is it safe to say then, if it wasn't for Marsh, then AU might be arguing for no prayers at all?
It's safe to say that Marsh it's safe to say that Marsh sort of limited the flexibility we had in what we could argue. I think
So again, if it wasn't for Marsh, would AU be arguing for no prayer?
I don't know if I'm actually not sure as an organization what our position is, or even whether we were involved in Marsh. I think we would certainly have more freedom to look at the issue sort of anew. what we would have actually argued, it's on the books and there's no chance it's going to be overruled. So I think it's fair to say that we were constrained by Marsh, which put us in a position of having to come up with a way to, on the one hand, allow there to be some legislative prayer practice, but on the other hand, protect the conscience rights of a more diverse audience, including our clients. Yes?
In this particular case, it appears that this was an administrative decision of a particular executive branch person and not a legislative action that created this prayer situation. Is there any difference because of that this was a singular person and that the practice had been changed from previous singular executives?
So, yes and no. I mean, so the way this board operates, they don't, and I think a lot of local governments are like this, they don't have a very defined separation of powers. At the federal level, we have like the White House, and then we have Congress, and we have the court. And it's three very, this is like the town board, which includes the members of the board, including the town supervisor, who is himself a member of the board and one of the voters. So it's really like 5 people, including the mayor, and they all constitute the town board. So it really is, in a sense, the legislature, the executive, and sort of the quasi-judiciary all in one. I don't think there's any contention that the rest of the board didn't go along with the supervisor's decision, but I do think the fact that this board acts in a number of different ways, that wears a number of different hats, impacts the way you look at it, because it does create situations where people are going before this entity to petition, to ask for things, that they're not just enacting broad legislation that's going to affect everyone, but they're adjudicating individuals' cases and requests. And so in that sense, it does increase the pressure on citizens, it increases the need to be inclusive, and it increases the risk that someone is going to feel compelled to join in a prayer because they want to, they want to win the favor of the very quasi-legislative, quasi-administrative body they're about to stand up and ask for something from. Yes?
What groups specifically were your allies?
So there was actually a number, in a case like this, there's a number of friend of the court briefs filed on either side. We had, 10 to 15 briefs, but some of the highlights were, we had a group of about 40 legal historians who looked at the founding fathers and the founding Congress, and there's actually some very interesting history about, for instance, presidential Thanksgiving proclamations. You hear these used a lot by the religious right. It's like, George Washington mentioned God in all his speeches. Clearly this was not a problem, but there's actually pretty clear evidence that the founders, including the founding presidents, even when they mentioned God in their Thanksgiving proclamations, were very careful to not, mention the tenets of specific religions. For instance, George Washington, he would get these chaplains, or in one case, Alexander Hamilton would draft these speeches for him. They put all these Jesus Christ references in it, and he would take them out because he believed very strongly that he needed to be inclusive. As a footnote to that, John Adams actually did include specifically Christian references, and then when Jefferson was running against him, attacked Jefferson for being an atheist, and after Jefferson won, John Adams blamed his defeat on his embrace of Christianity in office, and then later talked about, government has to be hands-off from religion. So that was actually a very important brief. All of this happening at a time when there's far, far less religious diversity than there is today. We had a brief of political scientists, in particular local government experts, talking about a lot of the things I mentioned, the way that local government entities differ in the degree of citizen participation and the degree of intimacy in a way that creates a lot more pressure on citizens to toe the majority line. We had a brief of progressive Christian groups, including the Baptist Joint Committee for Religious Liberty,